And welcome back. I am joined by Thomas Erb Jr., founder of Erb Legal LLC of Ohio. And Tom, I have been enjoying our conversation. Honestly, we should probably be hot mic'd, as they would say, because we're having fun off camera as well, talking about prenuptial agreements, but also postnuptial agreements, which is relatively a new thing in Ohio. So it's a novel area for you. And so tell our viewers how it is that Ohio now is dealing with postnuptial agreements and maybe some of the challenges or concerns there may be with this new area.
Ohio's only had postnuptial agreements since March of 23, when the governor signed it into law. Prior to March of 23, postnuptial agreements were invalid as a matter of law in Ohio. The postnuptial statute requires the same thing for a postnuptial agreements as they do for a prenuptial agreement. However, the statute does address that a postnuptial agreement can provide for an immediate separation of the parties and can provide for the support and care of the children. That's not the exact language, but the one thing that it doesn't address is visitation. So there's been a lot of debate in the Bar Association about whether or not you could put visitation schedules in a postnuptial agreement that would be enforceable. Because the statute's relatively new, I haven't seen any litigation coming out of the appellate courts on any of these issues yet regarding postnuptial agreements. Obviously, since they were probably first signed around 23, you got to kind of wait for the first divorce that brings it up, and then it's going to be at least a year in our appellate courts here before you get a decision on it. So we may not get a decision on any of these issues until a couple of years, maybe 26, maybe 27. So until then, we're largely relying on our experience in sort of knowing how the court's going to look at those sort of issues. There's a vehicle called a legal separation where you can handle all of that, which is essentially we're going to separate and divide our stuff now, and you can address children's issues in there. It was kind of bizarre when they passed it. It was kind of a surprise to everybody, but it's now here to stay. But unfortunately, there hasn't been a lot of success, at least here, in doing postnuptial agreements because we're together and now we're talking about dividing our stuff in the event of a divorce.
Find that interesting because, well, first of all, in Florida, we don't have legal separation. However, we do have a statute on the books that you can petition for support unconnected to a dissolution of marriage, which sounds to me like separation. But I find it interesting because in my experience, at least with my clients, when we deal with a postnuptial agreement, it's basically the parties say that the husband and wife, or the spouses, I should say, come back together saying, okay, we've been married 10 years. We now have two children, and I really want us to reevaluate how we separated or how we're going to deal with things in the event of a divorce. And let's just say that the higher earner, say there's one spouse that has given up a career, staying home with the kids, and the main breadwinner is now saying, you know what, I really want to be able to make sure that my spouse is taken care of, and that when the children are with them, say I want to make sure that the house that we bought is for her. She'll get X amount of life insurance policy guaranteed. Things of that nature are built in. That's how I usually have a postnup. And it does seem to coincide with certain mile markers in the marriage, like 5 years, 10 years, 15 years, and such. So I find it interesting. I gotta ask because it is a legal separation. So under that statute, do you file for a legal separation?
You can, yes.
Okay, you gotta teach me more, please.
You can file a complaint for a legal separation. It's very rare. 9 times out of 10 in the legal separations that I've done, we file the complaint with the entry, and basically the whole thing's over all in one shoot. Generally, I don't find legal separation to be practical for most people's situations. It just doesn't make any sense to do a legal separation and still be married, because if you want to go back and eventually get divorced or remarried, you're going to have to go back to court and potentially fight about the legal separation. Maybe that doesn't happen, but maybe it does. And always in the back of my mind is, what's going to happen 5 years from now when you go and file for divorce? Will one spouse say, oh, that wasn't equitable? And then we're going to go in and challenge it and fight about it. So why not just do it the first time? There have been a couple instances where I was like, oh, I understand why they're doing the legal separation. Because at the time, my client had cancer and wanted to stay on the husband's insurance at work. If they got divorced, she would be taken off the insurance. But if they just did a legal separation, she was able to stay on and get the treatment that she needed. So, in that sort of a situation, I could understand why they wanted to do it. But most of the time, I struggle when people say, I want a legal separation, let's divide our stuff, but still stay married.
Okay, so that begs the question. And I don't know California law, but you know how you always hear in California that you have to be legally separated for, say 6 month period, an X amount of time before they can petition for the divorce. Is that the same in Ohio?
No. So I know North Carolina has something similar. North Carolina, you actually have to live separate and apart. I'm not a North Carolina attorney, but my sister went through a divorce down there. They had to live separate and apart for more than a year and couldn't cohabitate in the same household for even one overnight, and then the clock would restart. We don't have anything like that here. I've had clients who've lived together through the entire divorce, who have lived together after the divorce. We don't have anything like that. Theoretically, in a legal separation, you could do that, but so far it's not happened.
See, okay, so this is just me thinking. In my mind is, okay, you are now allowed to have a postnuptial agreement. And in that postnuptial agreement, you can make certain assurances. Let's just say maybe not deal with child support or time sharing, but if there is an issue or something, or after 15 years of marriage or whatever, you want to renegotiate what you originally negotiated, or you just want to have something put into place. To me, that makes sense rather than going through a legal separation. Although, I mean, I've had friends whose parents had been technically separated for 30 plus years. They just never divorced. They just lived apart. I
Right.
mean, so I guess there's that. And also, then it begs the question, what happens with the testamentary rights that you have as a spouse if it's, like, at least here, life estate interest in a homestead property, the elective share, things like that. Um, Wow. Now I'm so intrigued on Ohio family law. Thank you. Because you guys are really, it seems like there's a lot of things that are happening. I know you were interviewed yesterday talking about some of the new legislative changes that may be happening. Seems like what Ohio is dealing with is what Florida had to deal with several years ago, where we now have a presumptive 50-50 timeshare. Uh, we don't use the word custody, but time sharing, and which does affect a lot of other issues, that not only just where the children are going to reside and bouncing back, but okay, I am just now enthralled with this legal separation because we don't have it. Thankfully, you don't have to have a certain amount of period that you before a divorce. um just out of curiosity, what is the threshold for a divorce in Ohio?
The threshold?
Yeah, like, do you have to have are you a no fault state, a fault state?
No, it's no fault. Incompatibility will do it every time. And if
Okay.
it's ever worth pleading any of the other ones, the you generally only plead one of the other ones when you're looking to make a case for, say, financial misconduct. For instance, adultery. You hardly ever see that actually pled or someone want to actually take that to, a full trial. However, there's been financial misconduct as a result of, adultery. They're spending money on the other person. That money is part of the marital estate, and you can go and get that back plus damages plus attorney's fees. Um, that's a fault divorce if you go that route. But the vast majority of the divorces don't get that uh, that far.
Okay, I'm gobsmacked that your legislatures actually still had that. Yeah, we're completely no fault. Supposedly alimony, I mean, we deal with adultery, or I will bring that up because, again, if you have, say, an extramarital affair and you're spending tens of thousands or more on the paramour,
Right.
yes, technically one half of those assets or that money spent is subject to equitable distribution, belongs to the other spouse. But I always get the objection whenever I bring up adultery. It's a no fault state because here we don't have that. It is a factor, but it can be a non-factor as well. So, um, yeah, now I'm definitely wanting you back so I want to play scenarios now because this is interesting because we don't have that. Our legislatures wiped out that, and as at least it used to be, if the legislatures personally had an issue, they would change the law so that it would fit their issue or become a non-issue. I don't know if that's been your experience.
That's how this whole bill on the parenting issues got started, was by a state senator who, this is the story I heard. Okay, but the state senator whose wife took him to court and tried to deny him shared parenting, and that's where this whole genesis started. Was with a state senator who introduced the first bill, and it was quite a while ago. As I said, it's been defeated 3 or 4 times now. But they finally put together a blue ribbon commission type deal to try and resolve um, some of the disagreements and the more unpalatable issues with the bill. Either way, this is what I always say. Either way, okay, even if we start at 50-50, there's still going to be litigation on the back end to try and take away the 50-50. So 50-50 is not going to be the be all end all like everybody seems to think it is here in Ohio. I still think you're going to see litigation saying, well, they don't deserve 50-50 because of XYZ. They live an hour away. It's not good for the kids to be getting up and going to school at, crack of dawn. Um, so I think there's still going to be a ton of litigation about it at the end of the day, which makes, both of us happy, but it certainly doesn't make the families happy, and it's certainly not in the best interest of the children to be doing all of that.
No, and I agree. So we have had several years of them trying to put in 50-50, and they were doing it under an alimony reform bill. And then it was nearly 2 years ago that the alimony reform bill was enacted or signed by the governor. And then also now there is a presumption that 50-50 time sharing is a right, but it's a rebuttable presumption. And so we still have to argue all the factors either in favor or not. Now, what's interesting is where I'm at in my primary practice in Lee County, Florida, they have been working under a 50-50 or greater than 35%, 40-60 before the legislation went in. So they were actually on the forefront. But you're right, it's not going to stop the litigation, and it it may cause more issues down the road. Tom, thank you so much for joining me on We the People. I am so impressed, and I'm looking forward to having you back because now I get to even have more fun and pick your brain on the differences of Florida and Ohio and learn how to integrate some of the things you're doing into my practice. And to you all, thank you for showing up for another episode of We the People. And I wish for you all to have a great night.